All right. This is date time set for the decision on bond motion. Was there any additional information or argument from counsel?
Yes, there is some additional information.
Yes, sir.
The courtroom falls completely silent as Judge Simpson opens a hearing on a motion to reduce bond. What should have been a routine legal discussion instantly feels heavier. A man's freedom hangs in the balance while prosecutors hint at something far darker beneath the surface. The defense argues there's no homicide charge, no proven cause of death, and no direct evidence tying their client to murder. But the prosecution paints a disturbing picture involving a dead woman, suspicious movements, and contradictions that keep piling up. From the very first exchange, the atmosphere feels tense and unpredictable. Every word matters because one wrong answer could destroy any chance of leniency. This isn't just about bond anymore. It's about whether the judge believes the defendant can be trusted at all.
The court was kind enough to adjourn it so that we could get a copy of the discovery, and we did get a copy of the discovery. If the court recalls, at the last hearing, I said, we don't know what the cause of death is. It could be, yes, it could be homicide, but it could be a drug overdose. I don't, if the court recalls.
I recall.
Two things that I would like to update the court on. First, I was puzzled by the medical examiner's statement that Ms. Blanche was kind enough to forward to me. She said it's consistent with homicide, but the manner and cause of death may never be known. Those two statements, to me, can be reconciled. So I actually called the medical examiner and spoke with her. And she said to me, I'm not going to talk to you about this because I don't have anything final. And I said, well, I saw the email that you sent to Ms. Blanche. And she says, well, that was a private email. Judge, I don't think it's the business of a medical examiner to be sending private emails not to be shared with defense counsel. But Ms. Blanche understood ethically that she was required to do it, and I commend her for that. So I don't have any more information, but she certainly couldn't explain how those two statements can be reconciled. But more importantly, Your Honor, I got the discovery. And the discovery, I'd like to read to you a portion of it. It's not very long. What was not in dispute in this case, or I don't think is in dispute in this case, is that Mr. Haraj had two escorts at his house that on the evening of the 22nd, going into the early morning hours of the 23rd. And one of the escorts was a woman named Tatiana Perez, who lives in New Jersey. And the police department went to New Jersey to interview her. And I'd like to read to you what it says. Perez said they returned to Habibi's residence in Dearborn after dinner. Habibi is Mr. Haraj. Perez said there was another girl, Susan, and that's the deceased in this case. Susan, Perez said there was another girl, Susan, she knows, staying at the same hotel in Novi, and asked if Habibi wanted her to call Susan over. Habibi agreed to this and arranged an Uber to pick Susan up and to bring her to his house. Perez said when Susan arrived, the three began drinking and hanging out by Habibi's pool. Perez said they went into another room in the house, and that is when they started using cocaine. Perez said she does not use drugs and decided to leave. So what we do know, at least from the other witness that was present, is that Suzanne, the deceased, was doing cocaine, according to.
Defense counsel tells the court they finally received discovery evidence and immediately focuses on one major issue. The victim may not have been murdered. The attorney explains that another woman present at the defendant home described cocaine use at night. According to the statement, the deceased allegedly participated while the other escort chose to leave. The defense carefully introduces a possibility of an overdose or medical emergency rather than violence. It's a strategic move designed to inject doubt into the prosecution's narrative. But there's a major problem. Toxicology results are not finalized, and no official cause of death has been determined. The judge listens closely but doesn't appear convinced. Instead of reducing suspicion, the cocaine discussion opens an entirely new concern about who may have supplied the drugs in the first place.
And could have overdosed, could have had a heart attack, so on.
But counsel, I mean,
And
I don't know if you want to make that argument. Because if depending on who supplied the cocaine, but certainly it being at the location, if it's that drug overdose that then results in a death, you got a whole other problem.
and I recognize that. But the evidence in this case, the discovery, there is no evidence, and I mean, burden of proof is on the people or the prosecutor. There is no evidence that those drugs were supplied by Mr. Hajar. Nothing. There was a white powder found in a backpack belonging to, who I think belonged to Suzanne, although that's not quite clear. Although the white powder did not test positive for cocaine. So I don't want to mislead the court. But the point that I'm trying to make, the burden of proof is on the government at every stage of the proceeding,
Judge Simpson immediately challenges the defense's argument with sharp skepticism. He points out that if the death involved cocaine, the legal consequences could become even more serious depending on where the drugs came from. The courtroom energy changes instantly. What began as a defense strategy suddenly starts working against them. The judge openly questions whether escorts typically bring cocaine to private homes themselves, exposing what he sees as flaws in the defense's logic. His tone becomes sarcastic but calculated. He isn't just analyzing law anymore, he's testing plausibility. The defense insists there is absolutely no evidence the defendant supplied drugs. Still, Simpson makes it clear that common sense matters alongside legal standards. The more the attorney talks, the more the judge appears unconvinced by the explanation.
burden of proof is lower at a.
But counsel, I don't leave behind my just common sense. I mean, I'm not sure or wise in everything in the world. Maybe somebody could tell me because I don't deal with escorts. So, I mean, I don't know if they bring their own cocaine. I would assume that that's not what happens.
But Judge, in all due respect, I mean, we're making an assumption where a man is presumed innocent, isn't even charged with this crime.
Counsel, this whole thing is full of assumptions. I mean,
No,
you're assuming it's a drug overdose. I don't know
No,
that.
I'm not assuming it's a drug overdose, but what I am saying to the court is the court was extremely concerned based on the evidence that Mr. Hajar may have been the one that committed if it was a homicide at all, and we don't even know that he was responsible for the death. But there's no.
No. Certainly that becomes a question, but to say I was overly concerned about that, here's what I have, counsel. I have his phone at the scene where this body is.
I'm not disputing that.
I have this woman, along with another woman, as I'm to understand it, that goes into his house. Her phone, the deceased phone, is pinged to his location.
The judge then turns to one of the most damaging details in the case, digital evidence. Investigators tracked the victim's phone directly to the defendant's home. After that point, activity suddenly stopped. No movement, no communication, nothing. Judge Simpson highlights that the last confirmed location tied to the victim was the defendant's residence. To the court, that creates a deeply troubling timeline. The defense argues this alone proves nothing, but the silence surrounding the phone becomes difficult to ignore. Modern courtrooms increasingly rely on digital footprints, and here, the timeline feels haunting. The victim arrives at the home and seemingly disappears from the world afterward. Even without a murder charge, the implications weigh heavily on the judge's mind. Technology has quietly become one of the prosecution's strongest witnesses.
And then it's time also to understand nothing else after that. So there is certainly a whole lot that can be made up in there or assumed to be, but I got somebody that's dead. The last place I had that person is his house. That's what I got.
That's what you got. I'm not disputing any of that, Your Honor. And that's why when I filed this motion, I didn't ask for a personal bond. I asked for a $100,000, 10% bond, because the defendant has not been charged with a murder, but recognizing that there are circumstances which might lead one to believe, although he's presumed to be innocent, that somehow he was involved in a homicide. But there's no evidence at this stage that it was a homicide. All we know is that this woman was found in a field. We can put him in that location at that time, but he hasn't been charged with the murder. And I'm not saying, Judge, and I maybe I'm just not making myself clear, but I'm not saying that it shouldn't be some kind of a cash bond, although the presumption in Michigan is to give a personal bond. But a $2 million cash or surety bond, where he has to pay a bail bonds person $200,000 that is not refundable. If the court believes that a $2 million bond is appropriate, which, again, in all due respect, I don't think is appropriate, then it ought to be at least a 10% bond. There's a case that the court may be familiar with, and that is People versus Reginald Davis. And in that case, the defendant was charged. Okay, I can bring the court a copy of it. May I approach the bench? Well, this is a case where the defendant was actually charged with murder, and the judge allowed him to be released on bond. The Court of Appeals reversed it because the statute says that bond shall be denied where the proof is evident or the presumption great. It then went to the Michigan Supreme Court, and the Michigan Supreme Court remanded it back, saying that's inconsistent. Is that inconsistent with the court rule and with the Michigan Constitution that says may be denied? Ultimately, the Court of Appeals ruled that a defendant can be admitted to bond even where the proof is evident or the presumption.
Defense counsel admits the circumstances look suspicious, but argues a current bond is wildly excessive. The attorney asked for a $100,000 10% bond instead of the existing $2 million cash or surety requirement. He emphasizes repeatedly that the defendant has not been charged with homicide. Under Michigan law, the defense claims the current charges carry far lower sentencing guidelines than murder. Counsel insists the Constitution requires reasonable bail, not financial destruction before trial. But the judge keeps returning to the same concern: public safety. Simpson makes it clear that the facts surrounding the case cannot simply be ignored because formal homicide charges haven't yet been filed. The defense want the court to separate suspicion from proof. The judge appears more concerned with the growing risk suggested by the evidence already uncovered.
He was actually charged with murder. The court does not say what the bond was in that case. But in our case, and the court said bond ought to be reasonable. That according to the court rule. So what I'm saying, Your Honor, is I'm not asking this court to release him on a personal bond. It's obvious to me, and I've been doing this long enough to read the tea leaves, that this court is not going to grant a bond that I've requested of $100,000, 10%, but a $2 million cash or surety bond where the defendant has not been charged with a homicide. It's not even clear that it was a homicide. I just think that that bond is unreasonable. So if the court made it a 10% bond, at least they could post it and maybe get some of it back at some point. But I also want one other thing. If the court will recall, if you look at all of the factors that are set forth in 6.106, one of them is a third-party custodian. I introduced the court to a former Detroit police officer who has known Mr. Hajar since they were in high school together. He said he would act as a third-party custodian. He's a retired police officer, but there's nothing in Mr. Hajar's background that would indicate outside of this offense that he has ever had any tendency towards violence. And I just think that while maybe a substantial bond, if the court feels it's appropriate, so be it. But $2 million cash or surety, I think, is excessive in violation of the Constitution. I've said my piece, Your Honor.
You would agree that reasonableness would also have to be balanced against one's means.
The defense introduces a Michigan appellate case involving a murder defendant who was still granted bond. Counsel argues a precedent proves even serious allegations do not automatically justify crushing bail conditions. Technically, the argument is solid. The attorney carefully explains that bond can legally be granted even when evidence appears strong. But Judge Simpson seems less interested in abstract legal theory than in the specific facts unfolding before him. He acknowledges the law while subtly distinguishing this case from the precedent being cited. The judge's patience visibly begins thinning as the defense leans harder on procedural arguments. Simpson understands the rules perfectly well. What concerns him is how the current facts continue pointing toward deception, concealment, and potential danger to the public.
Correct. And if he had $200,000, he'd be out by now, Judge.
So do you want me to go through and just pull all of his financial records and anything that he's attached to in order to make a proper determination of reasonableness? I mean, that's what's going to happen. I mean, if I take your argument, that's what has to happen.
If the court was prepared, if the court wants his financial information, I'll supply it. But again, if we talked about this, Your Honor, that I said that really whether he pays a bail bondsman $200,000.
Counsel, let's be real about this. Okay. Because I think if I take the financial things, my understanding is he's tied to 11 different businesses.
He works for Kenwell Steel. That's his main business.
Whoa. But that he has interest in 12 other companies or 11 other companies.
I don't think that's accurate, Judge. No, he has his own, he has a business on the side where he does IT work.
Come in.
There's one other business. And at this time, it's not even showing a profit. And if the court wants to put him under oath, subject to the penalties of perjury, so be it.
I don't need to do that to set a bond, counsel. You're really making this a whole lot more complicated, I think, than it need be. But, I mean, I'm willing to go there if that's what you want me to do.
Well, what I would really like, Your Honor, is if you could make it a 10% bond.
I know. That's what you would like.
That's what I would.
And the people object.
That's right.
That is where I'm trying to balance where I land on that.
Correct.
And I can only get there by what I see in the case, what risk he would pose to leave or what risk he would pose to the community.
But he would be on a GPS test.
The hearings suddenly shift from criminal allegations to money. Judge Simpson notes that if the defendant truly had access to $200,000, he likely could already secure release through a bondsman. The defense argues a real obstacle is collateral required for the full $2 million bond amount. That opens the door for the judge to question the defendant's businesses, financial resources, and outside interests. Simpson references information suggesting ties to multiple companies. Defense counsel quickly disputes those claims, insisting the defendant only has limited business involvement and modest income outside his primary work. The courtroom begins feeling less like a bond hearing and more like a financial investigation. The judge appears determined to evaluate whether the defendant's actual resources justify the current bond structure.
Not to live in his house and to live with Mr. Garza, he's prepared to do that. I've spoken to Mr. Garza, and he said he would put him up. But again, I just keep repeating myself, Your Honor, but the point that I'm trying to make is there is no evidence at this stage that there was a homicide, that the cause and manner of death. So what you're looking at is a guideline range of either 0 to 17 or 10 to 24 at tops at this stage. If he's charged with murder down the road, then of course the court would have the option, if the proof is evident or the presumption great, to deny bond and remand him. But at this stage, for these charges, even given what you characterize as suspicious circumstances, I think a $2 million.
Quit, counsel. You need to stop with what I'm characterizing.
With
I am just laying out what I know. That's all I'm doing. I'm not giving weight to anything at all. I'm just laying out what I know.
Right, but I think the court is concerned about the safety of the community because of the of the circumstances.
Anytime there's a dead body and somebody's around a dead body, yeah, darn it, I'm a little bit concerned.
Right. And understandably so. And that's why I don't expect the court to release him on some nominal bond. But $2 million, 10% is not a nominal bond. That's a substantial amount of money. And if the court wanted him to, in addition to that $200,000 10% bond, to post a house where he lives, we're prepared to do that. And then that gives some surety in addition. But I think a $200,000 cash or surety bond, they have to pay a bail bondsman this huge premium that will never be returned when he hasn't been convicted of a crime. He hasn't even been charged with a homicide.
Trying to regain ground, the defense proposes strict release conditions. They offer GPS monitoring, third-party supervision, and even relocation away from the defendant's own home. A retired Detroit police officer is introduced as someone willing to act as custodian. The strategy is clear. Portray the defendant as cooperative rather than dangerous. But Judge Simpson remains cautious. He points out that GPS tracking only monitors movement. It does not prevent deception or obstruction. The judge's focus keeps returning to risk assessment rather than punishment. This becomes one of the defining themes of the hearing. Simpson repeatedly frames bond decisions not as declarations of guilt, but as calculations about trust, safety, and future behavior. And with each new detail, the trust factor appears to weaken.
Only facing at this stage a charge that carries a maximum of 24 months under the guidelines. Now, I understand the guidelines are not mandatory. I know that. But, Your Honor, we live in a country where a person's presumed to be innocent. And there is no evidence in this record at this stage that this was a homicide, other than a statement that seems to be contradictory, consistent with a homicide, but I don't know whether we can ever determine the cause and manner of death. Judge, I've been beating a dead horse, which I said the other day, but again, if the court does not feel that something less than a $200,000 10% bond is appropriate, so be it. But I think that's a reasonable, fair bond under the Constitution.
Anything from the people?
Yeah, just briefly, I just want to make the record correct on the fact that the medical examiner didn't email me. I actually received the email through my officer, so she wasn't emailing me and saying, don't share this with the defense. That wasn't what happened. She shared it with my sergeant, and he sent it to me. So I just want to make the record correct on that. And he's right, this is not a homicide. That's why I'm not asking the court to deny the bond. I'm asking to set a bond. We had asked for $10 million to begin with. And under reasonless, he's saying they can actually post this bond. They just don't like the fact they're not going to be able to get the money back. Which, if you're making that statement, then how are you saying it's unreasonable when you actually can pay for it? You just don't like the fact that you're not going to get the money back. I was quiet during your argument, sir. Can I please finish?
Sure.
Judge, when it comes to cocaine, he's relying on, he's telling the court that a independent witness had suggested that the victim had ingested cocaine that night. I don't want to try this case right now on the record. However, the defendant said there was no cocaine at the area. He doesn't partake in those drugs, and there was none there that night. So there's conflicting statements around whether or not cocaine was actually at the place. So to just blanket say that we have a witness saying that, well, the defendant said there was no cocaine there that night. And this backpack that he says belonged to the victim, she walked in with suitcases that night.
One of the hearing's most powerful moments comes when Judge Simpson bluntly states the obvious. There's a dead woman connected to the defendant's home. The defense keeps emphasizing that homicide has not been proven, but Simpson refuses to ignore the seriousness of the situation. He explains that anytime someone is found dead and linked directly to another person's residence, concern is unavoidable. The judge's frustration becomes increasingly visible. He isn't accusing the defendant of murder outright, but he clearly believes the surrounding circumstances justify extreme caution. The defense tries once more to stress constitutional protections and the presumption of innocence. Simpson listens, yet his tone suggests he sees the issue through a broader lens. Community safety first, unanswered questions second.
The police asked the defendant for the suitcase she walked in with, and he doesn't know where they are. So I'm just concerned what's been kind of portrayed on the
Oh,
record.
hold on. I want to make sure I understand that. Who is saying that she walked in with suitcases?
Sorry, there's video showing her walking in with suitcases because she
Got
left the hotel, came to his house, and then the suitcases are gone.
Got it.
Judge, I don't believe the bond is unreasonable in these circumstances. I'm not asking you for the $2 million based on the fact that, you know, this is a homicide right now. I'm asking based on the fact of defendant's misrepresentations to the police that night, the fact that we have a missing woman last seen going into his house, never coming out, and then his car going up to Northfield Township, and she's found dead in the place that his car was at. That alone, those circumstances, I believe that he presents extreme danger to the public, and I believe based on that, you can rule $2 million for his bond, and I don't believe it's unreasonable because he's already said that he could post the $200,000 to 10% to a surety bondsman. So I don't know how you can make that argument, Judge.
I can tell you exactly how I can make that argument, because a bail bond.
After long stretches of defense argument, the prosecutor finally steps in to correct several key points. First, she clarifies confusion surrounding the medical examiner's email, insisting it was shared through law enforcement rather than secretly withheld from defense counsel. Then she attacks the cocaine narrative directly. According to investigators, the defendant himself denied any cocaine was present that night. That creates a major contradiction. If the defense now claims drugs were involved, why did the defendant allegedly tell police otherwise? The prosecution doesn't need to prove murder at this stage. Instead, they focus on inconsistencies and credibility problems. Every contradiction chips away at the defense's image of an innocent, cooperative man unfairly trapped by circumstances.
They'd have to post collateral of $2 million. They don't have that. That's the problem. If it was just the 200,000, it may not, they could raise it, although I think it's punishment to have to do a non-refundable 200,000, but the bail bondsman requires surety such as a house. And that's $2 million because the bail bonds person needs to protect himself. No one's ever argued that he was a risk of flight. And again, this is a man who's in his 50s and has never been in trouble other than a 12-year-old drunk driving.
Counsel, what about the suitcases? What about his statement regarding the suitcases?
You mean a statement about the cocaine?
Okay. No, about the suitcases. I mean, so that's part of the problem here. Part of the problem here is that there's going to be all of these things coming out that are going to cut one way and or another. And so I was, at least for the purposes of this decision, satisfied to say there are certain misrepresentations to people that was contained in the people's motion. But now when I get down into the specifics of what those misrepresentations may be, that raises more concern for me. I mean, because counsel, the witness you're talking about, you went through a lot of things about it potentially being something involving drugs. Then we find out, and you quote a statement about the drugs, only to find out your client's denying that there was ever any drugs. Then it just gets worse. I mean, at least in terms of my analysis of what risk.
Then comes a detail that transforms the hearing entirely: the missing suitcase. Prosecutors reveal video footage showing the victim entering the defendant's home carrying luggage, but investigators later could not locate the suitcase. Even more troubling, the defendant reportedly claimed not to know where it went. Judge Simpson immediately locks onto the issue. Physical evidence disappearing raises an entirely new level of concern. The judge's tone noticeably hardens. To him, missing evidence suggests more than confusion. It suggests possible concealment. The courtroom mood shifts instantly. What once sounded like speculation now begins resembling obstruction. Simpson openly acknowledges that this detail dramatically affects how he views a defendant's risk to the community and the integrity of the investigation.
Because now I have that woman walking in on video with suitcases. she leaves there, the suitcases aren't to be found. They ask for the suitcases, he doesn't know where they are.
There was one suitcase, it's not plural, but yes, the video
And
shows.
where's the suitcase?
Judge, I have not spoken to my.
No, but see, counsel, that's what I'm getting at. You want me to make an assessment regarding your client, the risk he poses. The more this stuff comes up, and when I ask the hard question, nobody wants to give me the answer.
I'll do my best, Your Honor. It's not unusual, at least in my experience, that people make false exculpatory statements.
I get it,
And
but they don't hide evidence. I mean, okay, that's the problem that I'm having now. Now, I come back today and there's this other added thing now. And that I think I can take into account in terms of the bond.
I'm not saying that you can't take that into account. It's never been my argument that you can't take those things into account. My argument is, Judge,
Counsel,
$2 million
tell me what I now do with now an indication that there is potential evidence that is missing, and a statement, I think, is at least an indication from people that your client is misleading authorities as to the location of that evidence. What do I do with that?
I'd have to go back and look at the discovery because I don't want to misrepresent what the discovery. I don't recall exactly what he was questioned about the suitcase, but I know it came up in the interview. I just don't have it in front of me. But let's assume that he misled, just for argument's sake, he misled the police about that. I go back to my original point that the bond in this case, if all of that is true, then still, I think a $2 million cash or surety bond is excessive.
Suitcase issue. Judge Simpson repeatedly interrupts with growing frustration. He points out that false exculpatory statements are one thing, but disappearing evidence is another matter entirely. The more details emerge, the worse the situation appears from the court's perspective. The defense attempt to minimize the suitcase discrepancy, arguing it may not impact the underlying case itself. But the judge disagrees. For Simpson, the issue isn't just whether the suitcase proves murder. It's whether the defendant can be trusted outside confinement. The judge repeatedly emphasizes that misleading investigators fundamentally changes his risk assessment. At this point, it becomes increasingly obvious that the court is leaning away from any meaningful bond reduction.
Might need to be more. If I come to the assessment that not only is he misleading authorities because he has the right not to say anything.
Correct.
That's one thing. But now when the statements are being made and he's misleading authorities and that it may look like certain evidence is also being secreted away someplace, that changes the whole thing.
I mean, I don't know. The evidence seems to me to be somewhat clear that they can place her in the house and place his car where the body was found. How a suitcase would add or subtract from the strength of the case, I don't see it. But I don't have any answer.
It depends on what you think happened.
Again, Your Honor.
And then it would also depend, and it may not add or subtract anything from the case. But then you have to ask the question, if I have an individual that then is not, though the defendants necessarily have to cooperate with authorities, but that is then not turning over evidence.
There was a
Counsel, that puts you into a whole other place. And you know that.
They did a search warrant on the house. They executed a search warrant.
No, but counsel, they know that something exists. They ask your client. They have proof that something existed when it went into that house.
That's correct.
They ask your client about it. Your client says that it's not there, whatever he said. you know that that puts any argument that's being made from any court's perspective in terms of reasonableness of the bond, that puts it in a whole.
Judge Simpson repeatedly returns to one word: risk. He explains that bond hearings are not solely about guilt or innocence. They are about evaluating danger, reliability, and public safety. Every contradiction, every questionable statement, and every missing piece of evidence increases the court's concern. The defense continues arguing that no homicide has been charged and no cause of death confirmed. But Simpson appears far more focused on behavior than technical charges. He openly states that evidence suggesting concealment or deception changes everything. The judge's reasoning becomes clear. If investigators believe evidence may have been hidden, a lower bond could create even greater danger moving forward. By now, the hearing feels less like a debate and more like a slow collapse of the defense's credibility.
That's what I'm saying. It's getting worse.
Your Honor, again, I don't want to just keep repeating myself. I'm not asking for a nominal bond. $200,000 is a lot of money. A lot of money for someone that's not charged with a homicide and is presumed innocent under our Constitution. Again, I'm not even, $1 million would be a sizable bond for someone with as it sits today, where there's no evidence that it was a homicide, that they haven't found the cause of death to be a homicide or the manner of death to be a homicide. And it would seem to me that.
But you have to factor into that. I also have somebody that it is also alleged as lying to authorities, who also is having evidence that they're not turning over to the police and or have secreted in some way and or destroyed. It doesn't go one way, counsel.
I'm not saying it does go one way. All I'm saying, Your Honor, is $200,000 is a substantial bond. If it's 10%, that's all I'm saying. I'm not asking the court to release him on a personal bond. Although it was my original request to do $100,000 10% bond, but he's not charged with murder at this point, and they haven't even shown that it's a homicide at this point. And it may be quite some time before that happens, and he sits in jail on a case that has, at worst, 10 to 24-month guidelines. That's my argument, Judge, and I don't mean to keep repeating myself. I'm just asking that the court reduce it at this point to a 10% bond.
Anything else in the people?
No.
Court's going to stay in recess. Everybody can remain seated. Back on the record, case of the People versus Hajier. Counsel is present. The court has reviewed the Court of Appeals case and read over the Court of Appeals cases provided by the defense. Let me first say, as I said at the end of the last hearing, I do not believe that the bond is set by the magistrate, at least based upon the information that the court had at the time, that this court had at the time, that this court could constitute or say that was an abuse of discretion. What is notable in the defense's argument, and all of it certainly being legally correct, but then again, taking those arguments and applying them to particular factual circumstances, at least as the court would know them at this time, may be where there is some difference. Notable is the defense's statement that the $200,000 that may be required to pay.
Despite the judge's growing skepticism, defense counsel continues returning to the same core point. The bond is excessive. He repeatedly reminds the court that the defendant is presumed innocent and still faces charges carrying relatively low sentencing guidelines. But repetition begins working against him. Judge Simpson appears increasingly frustrated hearing the same constitutional arguments while new suspicious details continue surfacing. The prosecutor barely needs to interrupt anymore because the judge himself is already identifying the weaknesses in the defense narrative. What started as a structured legal argument slowly begins sounding desperate. The courtroom dynamic shifts heavily toward prosecution, without them needing to say much at all. Sometimes, silence becomes the strongest strategy in court.
There is that the real crux of the issue is that should everything go forth through trial, through everything, where there would then be a release of that surety that the defendant does not get that back, or the monetary funds back. That is correct, but they're also not having to put up the entirety of the $2 million. But what's notable in that is that the $200,000 could be indeed posted. The more the facts are laid out before this court, the more the court has not just questions, but certainly has concerns about safety to the public. I don't doubt that there are individuals that had basically a full courtroom the last hearing, that there would be individuals who would vouch and that the defendant could be released to. That isn't really the court's concern. What is of concern to the court is that as this is ongoing, the risk, the danger, as it is uncovered as to maybe what occurred in this case, would lead the court maybe to a different conclusion as to the defendant's danger to the community and the threat that he may.
As the hearing nears its conclusion, Judge Simpson practically reveals his ruling before officially announcing it. He explains that every new fact uncovered in the investigation increases concern about potential danger to the community. He specifically references possible misleading statements and the concealment or destruction of evidence. The judge notes that some of these troubling facts were not even known during the previous hearing. That revelation matters because it shows his concern has intensified over time rather than decreased. Simpson carefully acknowledges that the defense's legal arguments are technically correct, but he stresses that applying those legal principles to these particular facts leads him somewhere very different. The courtroom can already sense where this is heading.
By way of example, certain facts today, some of them laid out in generalities, but not in specifics, were not known to the court just last week. And they do give this court great pause. And I don't think it unreasonable for this court to take into account what may be statements made for the purpose of misleading an investigation and or the concealment or the destruction of potential evidence in the case. One of the reasons why I wanted is counsel were going through everything last week, that the defense at least be presented with or have the discovery in case those arguments were made. That having been said, the court is going to rule in this case that the bond is set by the magistrate. As I've indicated, I don't believe is unreasonable. I do not believe, under the circumstances, I do not believe that it is unreasonable. I do not believe that it was an abuse of discretion in terms of the magistrate in setting the bond. To be quite frank with you, given what I learned today, it might lead this court to think that a higher bond might be required. But I'm not going to do that either. I'm going to leave the bond where it is at $2 million, cash or surety, so that it can be posted. I will do this, however. Should the defendant not be able to post that bond, I would give the defense an opportunity to produce to the court certain financials, which I think the court, certainly under the court rule and otherwise, can take into account in terms of his ability, not necessarily to pay the $200,000 to the bondsman, because it's already been acknowledged by defense that they can do that. The question is the collateral that would frame up to $2 million. And the court would take a look at that and then reevaluate if bond cannot be posted. The court would then reevaluate and take a look at the bond. I would also say, however, because of at least what the court knows or thinks it knows at this point in time, that as a additional condition of the defendant's bond, and I believe that the magistrate did order a GPS tether, I would order that if the defendant is released, he is to be a GPS tether is to be placed on the defendant prior to his release. It's indicated also he would have to surrender any passport or any other documentation which would permit him to travel outside of the United States. Additionally, as part of this court's order, given what I've seen here, that should there be enough evidence at some point, and this will be a condition of his bond, that if there be enough evidence that the people would file and charge the defendant with open murder, first or second degree murder, or any other type of homicide type of an offense, that the defendant bond as set would be canceled, and he would then.
Judge Simpson officially denies the request to reduce bond. He rules that the original $2 million cash or surety bond was not unreasonable and did not constitute an abuse of discretion. In fact, he admits the new information revealed during the hearing could justify an even higher bond. However, he chooses not to increase it. Instead, the judge leaves the existing conditions in place while offering the defense one narrow opening: financial reconsideration. If the defendant cannot satisfy the current bond requirements, the court will allow detailed financial records to be submitted later for review. Even so, the ruling makes one thing painfully clear. Judge Simpson believes the risks surrounding this case remain too serious for leniency.
Were to come about. And that would, as indicated, be a condition of his bond in this case. That is the ruling of this court. Is there any questions regarding the court's ruling?
I do have a question, Your Honor. Well, I have two questions. One is a comment, not a question. I had proposed to the court that in addition to if the court would impose a 10% bond, that in addition we would post a house, which would be similar to what a bail bonds would require. I'm not sure how much equity there is in the house, if the court would consider that. And I think there's a relative that would also post a house in addition to his own. So I would ask that the court consider that. The second question I have, the next comment I have is the passport is already in the possession of law enforcement. It was in a safe that was taken at the time, and that is in the discovery that they have possession of his passport. The question I have, if somehow at some point he does get released, can he work? I know he has to have a GPS tether, but I would like him to be, his employers, I gave a letter to the court last week, said they would take him back.
But would he leave the state of Michigan?
No, he would not leave the state of Michigan.
Originally, a home confinement was ordered, so I don't know if that was now unreasonable deemed by the court, but that was originally, the home confinement was ordered on his bond.
Without much else, I don't know that I'd order a home confinement. I would just order a GPS tether with location tracking at
Thank
this
you.
point.
Would the court consider if we can post 2 residences that equal, let's say,
Counsel, I think I was very direct
Okay.
in my,
okay,
that is.
I'm going to shut up, Judge.
If the bond as set cannot be posted, I'm giving the defense an opportunity to provide to the court financials that would lead the court in a different direction or to restructure his bond.
Thank you.
So with those conditions, defendant's motion is denied regarding a reduction or change in bond. I've given the opportunity for you to do other things and provide that to the court. I will look at it. I will diligently look at it. And if there's something that can be fashioned, I will do so.
I appreciate it, Judge.
All right.
May I have a word with the client and my co-counsel regarding the next probable cause conference?
Sure.
Okay.
The people will prepare their order for the court signature. Yes. You might, that microphone, you might want to hit that so that it's not picking up. They're very sensitive. So it needs to be green. It should be green if it's.
And I appreciate the court's patience. It's been the longest bond hearing I've heard.
Yes, and after 25 years sitting here, my longest one ever. So.
Your Honor, we would ask the probable cause conference to be put over 1 week so that we can see whether he has the wherewithal to post the bond under the current conditions or whether we need to present financial information. So that would be, let me just make sure I have that date open.
August 1st.
Pardon?
That would be August 1st.
August. Can I just check my calendar, Judge? That looks good. Do you want to do it at 3 o'clock again?
No, my PCCs, so here's what would happen. My PCCs are set in the morning. If you were to file something or wanted something heard, it gets switched to this 3 o'clock time.
Okay, fair.
So
Okay,
I set everything at 9. You will get a invite from the court, which puts you into one of the hour blocks throughout the day so that you're not here all day waiting.
okay, and then
You're
if,
set in the 9 o'clock block, because it's the in custody block, which currently he would be set in, is a 3-hour block, but.
great. May I approach the bench with the prosecutor for a moment?
Record should reflect we had a brief bench conference in this case. Probable cause conference in this matter will be set August 1st, 2024, 9 a.m.
I'm sorry, Judge. I didn't hear, I was.
It's August 1st, 9 a.m. for PCC.
Thank you.
Bond will continue in its dollar amount with terms as stated.
As the hearing finally concludes, the defense asks for additional time to determine whether the defendant can realistically post bond or provide financial records for reconsideration. Judge Simpson agrees to schedule the next probable cause conference while keeping all existing bond conditions intact. The atmosphere at the end feels very different from the beginning. What started as an argument about reasonable bail evolved into a broader examination of trust, credibility, and danger. The defense fought aggressively using constitutional principles, precedent, and fairness arguments. But in the judge's eyes, missing evidence and conflicting statements outweighed every legal citation presented. This hearing became a reminder that courtroom outcomes often depend not just on law, but on perception. Once a judge senses deception, leniency becomes incredibly difficult to recover.